Thank you so much for joining us today. My name is Lisa Smith. I'm the director of the Peking Human Rights Due Diligence Forum. And today we're having the final episode in our webinar series on human rights due diligence for climate change impacts. In the previous episodes, we have looked at the status quo, at climate change litigation, and at the legal duty itself. In today's final episode, we will be looking at meeting the standard. What does adequate human rights due diligence for climate change look like in practice? We're very excited about today's panel of experts. Thank you so much for joining us today. Our first speaker today is Manson Gwanyanya, is the Southern and Anglophone West Africa regional researcher and representative researcher for the Business and Human Rights Resource Center. He joined the Research Center after completing his articles of clerkship at the Legal Resources Center in Johannesburg, where he had also previously worked on migration and refugees. He was a junior researcher in the Social and Economic Rights Program at the Southern African Human Rights Commission and a sessional lecturer at the Wits Law School. Manson obtained his LLB, LLM in corporate law, as well as postgraduate diploma in environmental law from Wits University. He also worked as a research and teaching associate and sessional lecturer at Wits University, where he taught a number of undergraduate courses such as constitutional law, delict, business entities, and insolvency law. And we can see from all these topics, Manson, that you are absolutely the perfect speaker for our topic today, and we really look forward to your presentation. Thank you so much.
Thank you so much, Liz, for the kind introductions. Yeah, although I might say that most of what I'm going to be speaking about today is mainly based on the experience that I've had at the Resource Center as the Southern Africa researcher and representative. Also, thanks to the Institute for giving us this opportunity to share our thoughts and ideas with you. I just want to do, in the very short time that I have, I want to do one of three things today, Liz. And the first thing that I want to do is to speak about human rights due diligence in the African context, what it is that, what discussions we've been having within Africa among civil society, investors, and companies. The second thing that I would want to do in that, after that brief overview of the African context, is also speak to try to answer the question that basically the seminar, the webinar wants to address today, which is, what does human rights due diligence look like for climate change in practice? And in that discussion, I want to sort of bring it closer to home, speaking from the African context as well, but also highlight some of the resources and the research that we have done over the years at the Resource Center, some tools that we have that everyone can actually use to sort of try and get those answers answered. And then lastly, and but not least, I would also want to sort of offer some thoughts or some recommendations. And again, nothing of what I'm going to speak today is particularly new or unique. It's actually information that research that we have done at the Resource Center that we've shared at a number of platforms and various platforms over the years. So some of the recommendations and ideas that I'm going to share in the concluding phase, actually, you can find them in our benchmark reports and our transitional minerals texture, which are all available on our website. So those are the three quick things that I want to do given the limited time that I have. But before I do that, Liz, if you allow me, can I just quickly speak about the Resource Center and the work that we do in just a minute or 30 seconds. The Business and Human Rights Resource Center is an international NGO, non-profit making NGO, with over 18 regional researchers across the globe, basically. And as Liz already mentioned, I'm the Southern Africa researcher and representative. What we seek to do is to ensure that there is corporate accountability for human rights violations by all companies across the world. We also want to ensure that there's transparency in all dealings between companies and communities. And lastly, we seek to sort of support local advocates for human rights as well as civil societies within the regions that we work. So that's just a very, very, very brief sort of description of the Resource Center and what it is that we do. Now, to the presentation or the very short presentation that I'm going to do, I did mention that the first thing that I want to do is to speak about the human rights due diligence within the African context. The one thing that I want to mention before I go any further is that the question of human rights due diligence has not really been at the center of discussions within the African context for a number of reasons. And the one that I can actually just mention now is the issue of how we are going to enforce some of these things, because we already have quite a number of legal justice systems which we struggle to implement. So I must say that among civil societies, as well as investors and companies and human rights defenders in general, the question of human rights due diligence has not at this stage taken center stage in the African context. And as I said, the issues concerning implementation of these in the event that they do come into force. We already have quite a number of systems in place. The constitutions in quite a number of countries do cover some of these issues. We also have the Africa Mining Vision, which, although it only relates to the extractive industry, also do speak to a number of protections for communities as well as individuals and employees who work within the mining sector. Recently, there's also been growing support for the binding treaty on business and human rights, and there's also, in quite a number of countries, if I must also add, there are also environmental impact assessments, regulatory frameworks, which are already in place to ensure that when a company operates, they sort of try and avoid some of these harms that naturally come, and some of the things that the human rights due diligence seeks to look into. But like I said earlier on, there are still quite a number of obstacles, regardless of these domestic justice systems which exist. So again, moving to the second point, which I said, I'll look at some of the research that we've done at the Resource Center. It is clear that there is definitely a need for some form of regulation, and the question really is whether human rights due diligence is the appropriate initiative to answer those questions, or there could be more issues to do with general implementation of the current existing regulations within the African countries that are in the continent. So yeah, there are still a lot of issues that need to be done in terms of that, but let me bring it closer to the question that the webinar poses, which is what human rights due diligence should look like. I think I'll just amend that to say should look like in practice. And again, like I said, my focus will also be on the African continent. Number one, at the Resource Center over the years, we have done quite a number of research. And to us, I must add, climate change is human rights in as far as we are concerned. So we will not separate these issues to say this is an issue of climate change and this is an issue of human rights. To us, they are all the same. And we have realized that with this sort of growing trend globally from moving to fossil fuels to greener, going green, there's been a huge demand in a number of minerals that are used to ensure that there is going to be this just transaction. So one part of the research that we did over the years, I think this research started somewhere around 2012, was looking at the minerals that are going to be needed to ensure that this just transition takes place. So the minerals that are going to be in demand, the minerals that are used to develop low carbon technologies. And part of the work that we did in that regard was what we call the transition minerals tracker. And we looked at the 6 key minerals that are used to produce low carbon technologies. Amongst them was nickel, copper, lithium, zinc, and so forth. And what we did with this research was going to those companies that produce these minerals, trying to see if they have any policies that also speak to human rights due diligence, by the way. So if they have any human rights policies and what is their practice and so forth. And the idea there basically was to ensure that we have information that can be used by civil society, by investors, by companies, by anyone who might be interested in so to speak, to ensure that they have information that tells them how these companies operate and what precautions, if any, need to be taken, and what are the human rights risks that are associated with mining these minerals. And the findings there, I mean, because of the limited time that I have, I'm not really going to go to all the findings that we had, but I just want to highlight some of the key findings that we came across in this research. And like I said, the demand for these minerals has also led to a rapid growth in some of these companies operating, but there has not been any sort of significant steps taken to address the human rights due diligence impact of these of mining these minerals, as well as ensuring that when these minerals are mined, it is done in a proper and human rights sort of a human rights unique way. So these are some of the key findings that we found in the research that we did. And again, like I said, if you go on our website, you'll find all this information available. There is a very, very high increase in the risks that are associated with these minerals, which really pose serious threats to human rights violations. Some of the allegations that we found in these mining companies include environmental rights, access to water, land rights where people are displaced without fair compensation or free prior informed consent and so forth. And I just need to sort of drive the point here is that these are the research on this aspect of my discussion was only limited to minerals that are used to produce low carbon technologies. I'm going to speak more in the second phase of this discussion to the research that we did on renewable energy companies, those that are producing renewable energy. And you'd find that from the 24 companies that we sort of undertook the research, only 11 out of the companies had publicly available policies on human rights. So those that actually acknowledge that human rights is an issue and these are the steps that we take to address and so forth. 12 of the 24 had allegations, serious allegations of human rights, like I mentioned, from labor rights, contamination of water when they are mining their minerals and so forth. And none of these companies had taken any steps to respond to these allegations that had been raised against them. And that was very, very concerning in our part. And we really think that there should be something that is done. And we hope that the information that we've put out there can assist mainly investors who are going to be investing in renewable energy sources to actually take steps to mitigate some of these harms that might be that you'd find in these minerals that are used to produce low carbon technologies. The second and final, I think I'm also writing, second and final research that we did that I want to speak about, which does not necessarily speak, which is not necessarily limited to the African context, globally speaking. And actually, if I must add this, on all these companies that we researched on this on the renewable energy benchmark, none of them were operating in Africa. Now, the difference between this research and the previous research that I spoke about, the transitional minerals tracker, is that on this research, we looked at companies that are producing renewable energy and not minerals that are used to develop renewable energy technologies. So, and here it was only limited to wind and solar. So we looked at 16 of the largest companies within the world that produce wind and solar. And the aim here was also to see if they have any human rights policies in place and what practices they have to ensure that when they produce these renewable energies, this happens in a just manner, so to speak. I mean, there's this talk about just transition from fossil fuels to greener fuels, but no, many people really don't speak to how those minerals have been produced, which is what our focus is at the Resource Center. Now, out of these 16 companies that we researched, and just the methodology that we used there, we had a list of questions which we got from the corporate human rights benchmarks, which we ask the companies and ensure that they have certain things in place and so forth. And we found that only about 9 of those companies out of the 16 had a public commitment to human rights across all its activities. Only 9 out of the 16. So that's just above 50%, I think. So it's very concerning. We also found that a lot of these companies lacked essential policies to avoid abuse of communities and workers which operate in their firms, which is actually essential in our view to ensure that there is a genuine just transition, which we all largely depend on in order for us to avoid the impact of climate change. Like I said, 9 of the companies analyzed actually had, so only 9 had human rights policies in place. But what was very interesting in that regard is that none of the companies that we analyzed currently fully met the requirements of respect to human rights responsibility in terms of the UN guiding principles. Half of the companies that we sort of researched on, only 10% of them scored below 10%. So that's a very, very huge amount. 10%, half of them scored below 10%, sorry. And only 3/4 of the companies had 40% and above. And then the rest of the companies, majority had 22%. But these are some of the, just quickly, these are some of the key findings that we had. Human rights due diligence commitments, only half of the companies had those in place. 9 out of 16 had publicly available human rights policies. None of them had any remedies remedies and grievance mechanisms in place, which ensures that if something goes wrong, the communities or the workers can actually approach the companies for remedies for their grievances to be addressed. None of the companies also had any policies relating to land rights, which is particularly concerning. So those are some of the key findings. And again, you can actually look at all this research on our website, which is available publicly. Just in a very 2 minutes or so, some of the recommendations that we mentioned in both of these researches, and these apply to renewable energy companies as well, to those companies that are producing minerals that are used in the transition to low carbon technology. One, we recommend that all the companies should effectively implement human rights policies to ensure that they are in line with the UN guiding principles and international standards. Secondly, we also recommend that they must regularly consult with communities and workers to ensure that all their concerns are addressed on a regular basis. We also want the companies to adopt policies that protect human rights defenders, which was also a concern, particularly for our human rights benchmarks. None of them had any policies that look at human rights defenders. Investors, to the recommendations to investors, we encourage them to actually engage their companies to ensure that they have some of these policies in place which speak to human rights, due diligence, climate change, and so forth. We also ask them to demand that companies regularly report on these issues of human rights, due diligence, and they provide clear policies in place, which are fundamental for the transition from fossil fuels to low carbon technology. And then lastly, some of the recommendations that we put in place for the governments was to ensure that they adopt and enforce human rights safeguards through legislation, regulatory framework, is to ensure that companies that operate within their jurisdictions, particularly in Africa, which is actually a serious problem, operate in accordance with the international standards and as well as the United Nations guiding principles. And we also encourage governments to ensure that they enhance the access to remedy principle through legislation and so forth. And lastly, to civil society, we urge them to ensure that they keep an eye on all these companies, ranging from renewable energy companies as well as those that are producing minerals that are used for the low carbon technologies, and not necessarily think that all is well merely because these are the companies that are producing greener technologies and us moving to greener fuels. So those are some of the recommendations that we include in our reports. And I urge everyone interested to just go onto our website and view some of those research that we've done, which is quite eye-opening. I think I'll stop here, Liz. I might have taken quite maybe 3 more minutes extra. I apologize for that. Thank you very much.
Thank you so much, Manson. That was a really helpful and insightful overview, and in a record time as well. Really important points that you raised there, and bringing us, front and center attention to the transition to the green economy and how one should keep an eye on that as well. And it's such an integral part of the human rights due diligence framework as well. Thank you so much. So I just wanted to urge participants, if you have any questions for any of the speakers, we have a Q&A function. I'm not sure that we will necessarily get to live questions at the end. There might be a few minutes. But if not, it is also possible to ask questions in writing, and the speakers could potentially have a look there if there's anything they can answer in writing. So please go ahead and use that function. Thank you so much. So our next speaker is Joseph Waldramsing. He's senior researcher at the Amsterdam-based Center for Research on Multinational Corporations, also known as SOMO, and coordinator at the OECD Watch Network. Joseph leads SOMO's research and policy advocacy on energy, natural resources, and public services, and SOMO's Rights, Remedy, and Accountability program. As coordinator of OECD Watch, he frequently represents the civil society organizations in negotiations at the OECD and the UN, and has conducted extensive research and analysis on OECD guidelines cases. Joseph also serves as an independent advisor to the Social and Economic Council of the Netherlands. And in 2013, he earned a degree of PhD from the University of Twente Center for Studies in Technology and Sustainable Development, with a dissertation on sustainable development and corporate accountability in the global energy sector. He has since published several papers and peer-reviewed articles on the drivers and impacts of large-scale energy and extractive projects, and continues to advise communities and NGOs seeking to use the OECD guidelines to hold corporations accountable for adverse impacts. Thank you so much, Joseph, for joining us today. It's a pleasure to have you here, and we look forward to your presentation. Thank you very much.
Thanks so much, Lisa. Very nice to be here today, and thanks to all of you who are tuning in from around the world. Happy to be here today with this great group of people to discuss these important topics. I'll try to be brief. I'm going to focus my remarks as practically as possible on sort of some of the concrete steps and really trying to get to answer the question here about what due diligence means, corporate due diligence for climate change and addressing the issue of climate change. And I'm going to try to focus, my comments around the normative framework for due diligence that's been developed sort of within the OECD guidelines framework and the UN guiding principles, and is now very interestingly and importantly being translated into hard law, into national law in various jurisdictions through mandatory due diligence legislation. In various countries, particularly in Europe, France already now, but Switzerland and the Netherlands following likely closely behind. And of course, in Brussels at the EU level, also some very concrete paths forward on mandating due diligence. And of course, one of the big questions that is going around is, what is that going to mean for different sectors and for addressing different impacts? And climate change is one of the most important, the most pressing issues of our time that due diligence and these legislations is going to have to address. And of course, we've seen, interestingly, a number of, there's some jurisprudence that is starting to be developed within the OECD system because of it's been around the longest, let's say. There have been several NCP cases, OECD guidelines cases in recent years dealing with climate change. I think since 2011, which is when the climate change provisions were negotiated, we negotiated into the OECD guidelines. There have been 8 complaints about dealing with due diligence and corporate impacts on climate change or related to climate change. And 7 of those have been just in the last couple of years, the last 3 years, I believe. So there's really an increasing trend of communities and civil society organizations looking to use the mechanism that is attached to the OECD guidelines, the NCP mechanism, but really to get at the heart of what does due diligence mean for addressing the issue of climate change. So I'm going to draw some of my suggestions and remarks from these cases, and there are particularly 2 very interesting ones that I'm going to be drawing from. One is a case against a financial institution, ING Bank, that was filed several years ago by some NGOs that I advised in the case. And it looks at a bank's, a financial institution's responsibility for climate change and its due diligence related to climate change. And also under the French duty of vigilance law, there is now a complaint, a case against Total that has been filed by several non-governmental organizations that also sort of really tries to get at some of these issues of what does due diligence mean for a company like an oil company in addressing climate change. So just first, the basic premise, of course, I think in this due diligence framework is that climate change is a negative impact, a negative environmental impact that companies are expected to conduct due diligence to prevent, mitigate, and remediate. It's approaching climate change as an impact that needs to be addressed, and the due diligence framework then obviously provides a structure for companies to address that impact. And at first, it helps companies determine what their relationship between the adverse impact of climate change is, whether that's a causing, a contributing, or a directly linked relationship. The due diligence framework from the OECD guidelines and UNGPs has this relationship framework that I think is actually quite helpful in getting a wide range of companies who are contributing or linked in some way to the impacts related to climate change to start taking action. So this framework of causing, contributing, directly linked, and then the appropriate response, the appropriate steps that companies are expected to take in order to fulfill their responsibility and their obligation in some jurisdictions to address the impact. So, I mean, very roughly said, any company that's emitting a greenhouse gas can be considered to be contributing to the impacts associated with climate change. And companies whose products or services are linked to those emissions through a business relationship, such as a supplier or a client, should be considered to be directly linked to the impacts of climate change. And importantly now, under the OECD's due diligence framework, it's become clear that companies can shift depending on how they address their impacts from a directly linked relationship to a contributing relationship. And this is important, especially when we get to the actions that are expected of companies and the responsibility to remediate the impacts of an impact like climate change. So again, also importantly, in terms of practical things and practical steps that companies are expected to take in dealing with climate change through the OECD and framework, the due diligence framework, is that it's clear that the responsibility to avoid the impacts associated with climate change pertains not just to a company's own operations, to stopping, whatever greenhouse gas it might itself be emitting, but also in the value chain. That it is really expected as part of due diligence to take this value chain approach and look at how companies are related to or linked to other companies through business relationships, and that they also have a responsibility to seek to mitigate those impacts. Okay, so getting very practical here, I'm going to run through the 6 steps. The OECD due diligence framework has 6 steps of due diligence, and I'm going to apply these 6 steps to what it means for climate change. Just a couple of examples, and again, these are largely derived from some of the case jurisprudence that has come out. Step 1 of due diligence is about embedding policies and management systems designed to promote responsible business conduct. And if you look at this in terms of climate change, that means that companies are expected to maintain an appropriate system of environmental management, which includes managing climate change. So starting out with having a system, environmental management system that is specifically designed to look at climate change. That means mainstreaming climate change across your supply chain risk management processes. That means making sure that you are indeed in managing risks, environmental and human rights risks throughout your supply chains. That means including supply chain in those risk management processes. And that means other things like important corporate structure relationships, like having a board level position that is responsible for due diligence and for addressing the risks that are prioritized, such as climate change. So making sure that at a high level in the corporate management that these types of risks like climate change are addressed. Moving to step 2 of due diligence, that is about identifying and assessing the risks and the impacts. This obviously is the stage of due diligence where companies should be identifying climate change as an impact, as a negative impact, and then determining what their relationship is to it. Again, are they contributing to climate change? Are they directly linked to climate change through a business relationship that they have? Which are their products and services that are providing those links? Which are their business relationships that are providing those links? And then they need to, after having identified that this is an impact, they need to identify whether they are going to prioritize it. That's part of assessing the risks in due diligence. And now this prioritization, according to the OECD guidelines again and the UN guiding principles, this prioritization needs to be done on the severity of the risk and the severity of the impact. And that severity in turn is based on the scale, of the impact, the scope of the impact, and the irremediable nature of the impact. Scale referring to how serious the impact is. Scope, the number of people or the number of environment that is impacted, and irremediability is obviously whether or not it can be undone. And this is sort of the very practical framework that the OECD guidelines and due diligence gives companies for prioritizing risks that they need to address or not. And these three factors, if you look at climate change, make it pretty clear that climate change should be a very high on almost all companies' prioritization list. So this should be something that they are taking into account. Step 3 is about addressing the risks, to actually ceasing and preventing and mitigating the impacts. And of course, this is where the reduction of a company's greenhouse gas emissions comes into place, including those in the value chain. This involves exploring alternatives, and if no alternatives exist, really doing your best to mitigate the impacts, mitigate the emissions. And the OECD guidelines and UNGPs also insist that if mitigation is not possible, that companies really should be considering divesting or disengaging from certain business relationships, maybe even changing business models. Step 4, and again, step 4 and 5 are about tracking results and communicating about them. And this is really, these in particular have come out really clearly in some of the cases that have been filed, where the OECD due diligence framework was applied by the Dutch NCP in that ING bank case, and said that tracking and setting goals for reduction for greenhouse gas emissions reductions is really important, and that should be tied to the Paris agreements. At the very highest, the 2-degree standard, and based on some of the science coming out of the IPCC, probably the 1.5-degree scenario, and that companies should be looking at different methodologies to tie their own emissions targets, again, in their own operations and in their supply chains to these targets, and should be working towards reducing them. So again, looking at setting measurable objectives and targets for improving their performance is something that the due diligence framework would expect companies to do. And then communicating about that, communicating about the entire due diligence process is step 5 of due diligence. And that involves, again, making it clear to stakeholders, and particularly impacted rights holders, about the fact that these targets have been set, being clear what companies' impact is, how they assess their own impact. This is something they should be communicating about publicly, what targets they themselves set for those to reduce those impacts, and what steps they've taken in order to do that, and the impact of those. And then finally, step 6 is about remediation, and this is of due diligence, and this is where companies that are considered to have contributed to an impact are expected to contribute to the remediation. And now there's obviously a big discussion in an impact that is as huge and as diffuse as climate change. What does it mean for a company to contribute to remediation? And again, the OECD guidelines, the due diligence framework, offers some suggestions about this. Things like, setting aside part of your profits from a particular loan or from particular activity to go into remediation funds, assuming that there are going to be these impacts. But again, this can take various steps, and there are some very concrete suggestions made in a couple of in the Dutch NCP's final statement on the ING case, and some of the other ones that are going to be coming out. So I'll leave it here for now, Lisa, and if there are any questions later, happy to take those.
Thank you so much, Joseph, for that really, really helpful breakdown of the 6 steps with respect to climate change. Really, really helpful. Our next speaker is Colleen Tron, is founder and CEO of Ardia International, a specialist company that provides sustainability, business and human rights, and modern slavery expertise. She's a fellow of the Institute of Environmental Management and Assessment and a research fellow of the Center for the Study of Modern Slavery, St. Mary's University in Twickenham. Colleen is a tri-qualified solicitor with over 25 years of legal and commercial experience working with business organizations and NGOs across sectors and providing training and online resources. Colleen has an LLM with distinction in environmental law from the University of Aberdeen and lectures on business and human rights and environmental issues at Birkbeck School of Law and University of Westminster Business School. Her book, Strategic Sustainable Procurement, Law and Best Practice, is published by Routledge. Thank you so much, Colleen, for your insights today.
Thank you so much, Lise. Thank you for that introduction. And let me just open up my slides. Hopefully you can see them from there. Okay. What a great opportunity to be here to speak today. Thank you, Lisa. You know, I feel really humbled by the other people who are participating and their insights, and I was scribbling madly, Joseph, with what you were saying, as I think there's so many practical points that have come out of your suggestions. So with regards to what I want to share, just very briefly today, we'll be looking a bit around what the law currently, the state of the law currently around human rights and climate change due diligence, but with an emphasis of where the trend's going, and then particularly what are we seeing with business and how can they be reacting to this kind of these moving trends around mandatory due diligence. I don't have to introduce myself, and just very briefly around ADIA, we work internationally, and we support businesses with the development of their policies and their due diligence processes. And we also have a range of online training, which I hope to share at least one of the workshops with you at the end of my conversation, as it relates directly to what we're speaking about today. I thought this was a very interesting picture, because if you hadn't seen it before, it's one that was produced by the World Business Council of Sustainable Development. And it just shows you the human rights reporting provisions that have been developed since 2012 in 48 of 60 countries. And I think just by looking at that, you can see the huge growth in the requirements around reporting on, this is particularly around human rights issues, but we've seen the same around sustainability and environmental reporting requirements. And there's a 2016 report which was done by KPMG. I'm sad to see that it hasn't, a more recent one hasn't come out. And normally it was launched at the GRI reporting conference in Amsterdam, but those reports indicated a 68% growth in mandatory reporting. From a practical point of view, what this does for companies is obviously challenge them about whether they are operating within the local legislation requirements, and how, of course, that also fits in around international law and the broader frameworks around the UNGPs, and of course with climate change, the CDP reporting and all the other kind of reporting voluntary frameworks that have come to the fore. Going back to the point about where we are with reporting laws and with due diligence, I think that it's quite interesting or helpful to maybe just have a think about what kind of laws are currently in place relating to reporting and relating to due diligence. And there is a distinction, and I'd like to just draw on that in the 10 minutes that I have today. So the current mandatory reporting requirements legislation are probably laws that you are all incredibly familiar with. I could add to that the Companies Act of 2006. There will be other particular environmental legislation that I haven't actually added to the slide, but these provisions actually ask businesses to be transparent about the steps that they take. In this case, the ones I've indicated around modern slavery, what are the steps they're taking to combat modern slavery within their organizations and their supply chains. But it is a transparency, a reporting requirement with no enforcement penalties for failure to do that, other than, you know, potentially civil injunction under the Modern Slavery Act for a company that hasn't produced a slavery statement. So those are the sort of trends we've seen in domestic legislation around mandatory reporting requirements. But what we are seeing now is this move towards actually asking increased transparency, or including increased transparency, but actually with reference to around due diligence systems, which cover both environmental and human rights legislation. And I've seen reference to this as a sort of second generation of human rights due diligence legislation, which it goes further than the first generation, which is what I've just indicated around the mandatory reporting requirements, which is just around transparency. This trend is to ask businesses to include risks identification, an obligation to take action, and then to report on the measures, including the outcomes that they have taken. Around this, and sort of linked to the third generation, which is what I'm going to go on to, has been what the European Union has been talking about, which is to introduce mandatory due diligence around actual companies taking action to do stuff, and then to report on it. And the backing that has come for this legislation is from institutional investments, and I think also companies. And that shift is particularly interesting, is to see that there's so many businesses that have put their name behind mandatory due diligence. And the reason for that, I think, is really clear, is because for lots of businesses who are actually seeking to do the right thing, who are looking to meet their legal obligations, but actually to ensure that they manage both their organizations and supply chains in a responsible way, having a law that sets out exactly what they require does two things. In the first instance, it gives them the opportunity to understand what mitigation measures they might put in place. So what is really going to be clear about what is required of them and how they do that. So that helps them in their resource management. It helps them from a governance perspective as to why these things are important, but it also levels the playing field. And I think certainly what I've experienced in the last 10 years has been a number of companies who feel that it's unjust that they put a lot of time and effort into something where other companies are still cost cutting, they're not taking into regard what is expected of them, and they're getting away with it. And I think, to be honest, that COVID has really exemplified those distinctions in how businesses feel around this agenda. There are certainly those that are still wanting to do the right thing, spending money in developing their approach to reporting and due diligence. And then there are, of course, a number of others who are just using COVID and any other excuse to simply do nothing. Looking at examples of human rights due diligence laws, I mean, it's been mentioned already earlier by Joseph, looking at the French duty of vigilance law, then the Netherlands child labour due diligence law, and we've also seen the introduction of the EU conflict minerals regulation. All of these are examples of laws that are speaking specifically to the requirement of due diligence, that a company actually has a due diligence system to carry out a risk assessment on how it manages its human rights and environmental impacts, and then how it will go on to report on it. Now, I just wanted to make this point, and actually earlier this month, Lisa and I had such an interesting conversation around this particular issue, the distinction between reporting obligations and due diligence obligations. And I'm not sure that enough is being said around this, because I've seen in practice too that there is often a bit of a confusion around what is required from business in terms of what they do and what they say they're doing. And I hope that by just bringing this to the fore, that perhaps it will raise more conversation, but also bring some clarity around this issue, is that, you know, a reporting obligation is an obligation to disclose on what you are doing. It is not actually the obligation to do something as such. And the criticism that arises around reporting legislation is that it's easy for business to comply because they can simply write a statement, as we've seen, endless modern slavery statements that are out there that don't particularly actually identify what a business is doing, or more importantly, the effect of those statements and how what they are saying they are doing is embedded in their practice and actually making a difference around supply chain management. So there's a real criticism around reporting, in that it doesn't carry an obligation for a business to act on the risks. But the due diligence legislation that is coming through, and hopefully what we'll see with the EU, is different, because it will set a requirement for a business to do something, to actually take action and to put in place measures that are adequate and effective. And I'm sure that what we will see in due course, when we have more cases coming through, more clarity around the laws, particularly if we have civil penalties attached to these pieces of legislation, is that hopefully more businesses will actually be doing what they say, and that we'll be able to see effective measurement around these particular issues. So just to clarify, human rights due diligence, I think, is particularly requiring business to act on negative impacts and to provide remedy. There's a requirement to publicly disclose on these efforts, and human rights due diligence laws will also set specific standards. They are normally tied into the UNGPs, as we've seen with the French vigilance law, or the OECD guidelines. I think a point that was made earlier is that the actual content around due diligence per se is something that's going to have to be really fleshed out. And I'm not sure that we've seen a lot of discussion around what those standards and obligation requirements will be when we try to tie in both human rights and environmental due diligence, because from a practical point of view, they are often addressed very differently in business, and that's been driven by the way that the law is created and the different ways of measuring impact, the different mitigation around legislation, so defenses, that kind of thing. So I think there's a lot that has to be thought about, and how we actually pull these things together. And of course, that's going to give challenges to businesses themselves, because what we see constantly is within business is the sort of silo effect still around how these things are managed. We did produced a publication with IEMA in 2018 around how to manage compliance with both environmental laws and human rights laws. As part of that publication, I ran a number of stakeholder engagement workshops across the UK to really assess what the barriers were in business to managing compliance, particularly around environmental and human rights issues. Compliance is obviously the baseline measure that you're going to have when you're talking about due diligence. But I think, what was really clear is that there still is such a silo effect in these two things. And you often find that the managers who are dealing with environmental issues are now being asked to deal with the human rights issues. And they have a different expertise, a different insight into how to manage, say, environmental issues versus human rights. And so there has to be a lot more done around the education piece, around actually resourcing people within businesses themselves to work on a more cross-functional way to address the silo issues. And these are just a few thoughts that I've had sort of working with different companies of, what can business do to prepare human rights legislation. I think it's really critical that they establish a means of documenting current and proposed regulations. I'm always surprised about how many businesses, large ones particularly, actually don't have an appreciation for what laws are in place, what they're actually already required to do, not even considering what's coming across the threshold. So, and then also that there's not often a central mechanism of documenting these regulations. So that's one element. I suggest also that companies have to really stand back and identify what processes they have in place, do a gap analysis. What is there? What do they have? What don't they have? Aligning what they do with international standards. I see that so often as well, is that, you know, ILO standards, UNGP standards are not actually referenced in codes of practice or supplier codes of conduct, and I think that really needs to be thought about. Just one thing on that side, we just recently did some work with Westminster University around codes of conduct. We have a white paper that's being published in November, so anyone who would be interested in the webinar around that and the white paper, just to go on our website and sign up for the release of that. Just the other 3 points, I think, really assigning cross-functional due diligence and ensuring that there's adequate time and resources that are available, assessing what additional data or evidence is required in order to produce human rights disclosures. And finally, if an organization is a parent company, to really establish the lines of communication around subsidiaries. I've put that in particularly because we have a number of, we've seen so many questions arise around subsidiaries and parent companies in the last month or so. So that's really my presentation for this morning. I hope it was a very quick canter. I hope that what I've said has pricked some interest, and I hope also some questions that will come out of this. So thank you very much, Lise, and everyone else.
Thank you so much, Colleen, for that really also, again, a wide variety of points from the company perspective, and the nuanced approach that also exists within the, you know, from one company to the next. Thank you so much for that. So our next speaker, Nabylah Dehman, joined the PRI in June 2017, where she has been focusing on social issues as part of the ESG team. At the PRI, Nabylah supports investors' efforts to address social issues such as human rights, working conditions, and responsible sourcing with companies in their portfolio, both through collaborative engagements and publications of practical guidance. In recent engagements, Nabylah has been collaborating with investors on pushing the adoption of the UN guiding principles by mining and oil and gas companies, on responsible sourcing of cobalt practices by electronics and automotive companies, and on the just transition agenda. So prior to joining the PRI, Nabylah completed a PhD in political science at Sapienza University in Rome, and she also holds an MA International Affairs from Luis Guido Carli University and a BA in International and Comparative Politics from the American University of Paris. Thank you so much, Nabylah, for joining us today and for bringing us the investor's perspective, the very important perspective. Thank you.
Thanks a lot, Lisa. Yeah, thanks for your invitation, and very happy to be speaking today, and hopefully to provide a bit of a different perspective from the investor side. So let me see if I can put my slides up. Is that working? Great. Okay.
Yes,
so
Nabylah, it just still has to go onto the slideshow view. It's
somehow don't seem to be working. You still can't see it, right?
We can just see the actual slides, but not the slideshow.
Yeah, I'm giving you control. Hopefully that works.
Yeah. Perhaps just a little bit delayed. Is it actually displaying as a slideshow on your screen, or?
So it's coming up on one of my screen, which is
it's maybe because it's two screens. We had this issue previously. Sorry about the technical issues.
At the top, you should be able to choose which screen you're displaying.
Let me see.
Thank you, Jason.
Sorry
and I think the feature you're looking for is in the Zoom feature, not
Zoom
on the
itself.
PowerPoint.
Yeah.
Oh, okay.
Sorry about that. Yeah, on the Zoom function.
Go to the top where it says View Options.
Mhm.
Does that work?
Because I think because I'm sharing my screen, I can't. Do you want me to try and share a PDF? Maybe that.
No, I think it's okay. I think if
All
you,
right.
I mean, we can see them. It's just a
Okay,
little bit
great.
smaller than it would otherwise be, but I think it's absolutely
All
fine.
right. All right,
Thank
let's
you.
kick off then. Yeah, so I'll try to structure my remarks. I'll give a brief introduction of the PRI and the work we do with investors, talk a bit about ESG, and then go into a bit of a description of the work that we've been doing around human rights due diligence for investors, and how investors have a responsibility under the UN guiding principles and the OECD guidance on responsible business conduct for institutional investors, and then touch upon the work that we've been doing on just transition, and we'll end the presentation with some final considerations, which I hope can bring a bit of color to the discussion. So in terms of the PRI, so we've been created in 2006. So in 2005, the then United Nations Secretary General Kofi Annan invited a group of institutional investors to join a process to develop principles for responsible investment. So a group of 20 investors drawn from 12 countries actually was assisted by 70 experts coming from the investment industry, intergovernmental organizations, and civil society. And so together, they created these principles that were launched at the New York Stock Exchange in 2006. So at the beginning, we had 100 signatories to these principles. Today, we have over 3,300, representing around 100 trillions of assets under management. So that's about half of the assets in the world. In terms of the principles, I won't go in detail through those, but they basically revolve around how investors should incorporate environmental, social, and governance issues into investment analysis, how they can engage and be active owners, so engaging with investee companies to improve investee companies' practices, trying to seek appropriate disclosure around ESG issues to level the playing field there as well, and to collaborate within the investment industries to try and gain more leverage to push for these issues. We also ask our signatories to report every year to us on how they implement these principles, which is quite a lengthy process for investors. And just like corporates are not necessarily fans of reporting, our signatories are also sometimes a bit reluctant, but yeah, it allows to kind of get a bit more accountability as well among them. So in terms of ESG, so historically, obviously, there's been, I think, more ease in dealing with environmental issues just because it's been easier for investors to kind of measure environmental issues because the measurement tends to be quantitative. So it's easier to then integrate into their investment decisions. The social of ESG has always been kind of the poor cousin of the three, and it's been quite a journey to try and push investors to realize how they can engage on human rights and how they can integrate these assessment of their investee companies into investment decision. And historically, obviously, climate and human rights have been managed and addressed separately, governed by different policy frameworks, as we've seen, addressed by different communities of practice and managed by different tools. And it's been the same in the ESG space. There's also traditionally been a tendency to work on environmental and social issues in silo. But there is an increasing awareness in the investment community that we need to adopt a more holistic approach to these issues. In part because the known impacts of climate change really undermined a range of internationally recognized human rights, including the rights to life, health, food, adequate housing, property, and water. So the fact that there is an absence of adequate protection for human rights and that it exacerbates the vulnerability to climate impacts, and that these situations of increased vulnerability also expose these populations to other human rights violations like forced labor, etc. Is something that is very much becoming at the heart of investor preoccupations. And there's been a global financing challenge around both climate change and human rights. I mean, both represent a global financing challenge, and addressing these issues is definitely crucial for investors to protect their long-term returns and reduce their portfolio risks, because the institutional investors that we work with are commonly known as, and largely, they're universal owners, which means that their holdings are so widespread across the economy that the financial impacts affecting society at large are likely to also impact their overall portfolios. So even if some companies or some sectors do better or worse, these kind of systemic risks will have an impact on the overall performance of the portfolio. And we've seen that climate impacts such as extreme weather, food and water scarcity, increasing income inequality, conflict, and mass migration could all present a long-term risk to long-term investors. So while they've been taken often in isolation, investors are increasingly aware that climate change is part of a set of interrelated global issues. And we've seen an increase over the last years of investors' activities aimed at improving human rights due diligence. I think it was Colleen who was just mentioning that 101 investors have been calling on the EU to get to provide some guidance on and legislate on mandatory due diligence. So we've seen an increase in activity and advocacy from the investors, from the investment industry as well. And the UNGP definitely provide a common due diligence framework for both companies and investors, and the support of investors for the UNGP continues to grow. So that's what we've tried to articulate in our position on human rights at the PRI, to try and raise awareness among the investment community, because we're conscious that there's a core. It's a minority of institutional investors that are very much active on human rights, but the majority of the industry is still very much unaware of their direct kind of responsibility to respect human rights as defined by the UNGP and the OECD guidelines on responsible business conduct. So what we're trying to do with this is really to not just raise awareness among our signatories, but also to raise the bar in terms of expectations for investors, and to translate these expectations into practical steps that investors can be taking in terms of human rights due diligence. So because we've seen that there's such a momentum from governments championing human rights and embedding their expectations of investors into regulation, as I was saying, in parallel, we've also seen an investor momentum on human rights. And leading investors recognize that meeting international standard leads to better financial risk management, and that it helps align their activities with the evolving demands of their beneficiaries, their clients, regulators. But as I was just saying, a lot of the investment industry is still very much either unaware or like unclear on how they can fulfill their responsibility to human rights. So to close the implementation gap, we've set out a framework for investors on how they can implement respect for human rights in their investment activities. And this is really a key part of our work in supporting investors to also shape and enable real world outcomes in line with the SDGs. It's really ensuring respect for human rights is also very much central to achieving our 10 years blueprint for responsible investment, which aims to bring responsible investors together to work towards sustainable markets that contribute to a more prosperous world for all. So I've put down here a few of the initiatives that kind of showcase investors' involvement and in the investor momentum on human rights. And this is a bit of a simplified visualization of how where investors sit in the value chain. So obviously all entities can cause negative human rights outcome, and therefore they have a responsibility to respect human rights. But for this to happen effectively throughout the chain, each entity must identify their negative human rights outcome and communicate what they're doing to others. So to those above them in the value chain, to government, to business partners, to client, and to beneficiaries. So to understand the exposure and the actions required, an entity in the value chain needs to actually request information from the entity below them. So this flow of information that's featured on the slide allows, for instance, in the context of investment, it allows a pension fund with outsourced investment management to be aware of the human rights outcomes that they're linked to through their portfolio. So this is where you see the asset owner and the flow of information from the investment manager. So as due diligence is really often lacking, alongside seeking information from further down the chain, we're also recommending that investors should actively work to fill potential information gaps through service providers, through NGOs, through governments, media, and affected rights holder. So it's often obviously a bit more complicated than what is displayed on the screen, because a lot of investors use funds of funds, benchmark administrators, engagement providers, stock exchanges, or other financial intermediaries. So while this is more complicated, we still consider that institutional investors retain the influence to obtain information, identify adverse human rights outcomes, and address these issues. So while they can cause negative human rights outcomes through their operational activities, investors are primarily responsible or linked to negative human rights outcome through their investee companies that are the one directly causing or contributing to negative outcomes, with the investors being linked to them through their holdings. So investors, either on their own or collectively, should therefore exercise their leverage, their influence, to ensure that the companies in which they invest prevent and mitigate those negative outcomes, and that they provide access to remedy where the harm has already occurred. So we are asking of institutional investors that they have a policy commitment, a due diligence process, and where obviously the investor is directly linked to that negative or directly causing that negative outcome, that they must enable access to remedy for those affected. So the policy and due diligence process should cover the human rights included in the international legal instruments and also extend to climate change related impacts. So the due diligence system we consider to be really the backbone of day-to-day management of activities. And unlike investors' traditional risk management system that are focusing on business risk, operational risk, or financial risk, the core component is a focus on the risk of negative outcomes for people. So trying to really shift that narrative as well, and using a vocabulary that investors are using in different contexts and applying that to the human rights space. So in terms of the leverage that investors can use, there are different ways that investors can use their leverage. They can do that through investment allocation. They can do that through stewardship activities, so engagement with investee companies and engagement with policymakers and key stakeholders. But if an investor lacks leverage, it should also seek to increase leverage by, for instance, collaborating with other investors. We're also, as you can see, like providing some details around how an investor can escalate if the investee company is not responsive to the engagement. So if an investor is asking a company to improve their human rights practices and see no progress, there are ways that they can escalate the dialogue, which ultimately can lead to an investor divesting. So this is the decision-making framework of how investors can basically use their influence. And we've seen so in the work that we're doing in terms of human rights and climate change, I think one of the obviously the most striking, which has already been mentioned quite a few times today, is the just transition. So the work around the just transition that we've been doing with investors for the last 2 years. And we have an investor statement of commitment to the just transition agenda that was presented at COP24 a couple years back, that's been signed by 160 investors representing over 10 trillion of assets under management. So quite a substantive group. And we've been really working with them into figuring out how investors can play a role on the just transition, and the different, the different areas. And I think Manson, when he was talking, about renewable energy companies, that's something that we've been looking at. So it's not just about making sure that we protect workers that will be affected by the transition away from fossil fuels and other industries, but also for these climate-friendly sectors where new jobs are created. How do we make sure from the get-go that these jobs are decent jobs, that the communities around renewable energy companies' operations are not negatively impacted? So really trying to open the realm of the different aspects of the just transition, and working with investors so that they can play a role in pushing this agenda forward. And similarly, with the engagement that we're doing on cobalt, it's very much framed around cobalt being the demand for cobalt being driven by the boom in electric vehicles. So really, really something that's key for the transition to a low carbon economy. How is that articulated in terms of the human rights violations that we find in the upstream of the value chain? So how can we make sure that the companies that are producing electric vehicles are not doing so on the back of these human rights violations in the upstream? And I just wanted to finish with, I'll skip a slide, yeah, just a few final considerations in terms of what we're hoping to see, and what I think would be some interesting developments. So in terms of legislation, I think, yeah, we should definitely aim at getting a more robust and binding mandatory human rights due diligence requirement to level the playing field, and one that address the anthropogenic climate change, given the serious and irreversible harm that it's causing to rights and livelihood. Requiring business enterprise to actually align their operations with the goals of the Paris Agreement on climate change seems especially pressing in light of the research that shows that some entities, including financial institutions, actually bear responsibility for an enormous proportion of current and historical emissions of greenhouse gas. A binding legislation would set common standard that would bring about uniformity and legal certainty, and go a long way in leveling the playing field. And that's also related to the third point around driving meaningful data, which is key for investors, being able to really assess the performance of companies with regards to human rights, and mitigating the negative human rights impact of climate change, would allow for better asset allocation, for better engagement, more informed dialogue with stakeholders, etc. In terms of clarifying investor responsibility and action with respect to human rights due diligence in climate, I think that point is quite important, because we see already in our work with investors that they are the most remote actor in the chain. So for them, it's often hard to, they're one step further than companies. So getting that information can be a bit tricky, and really realizing that connection to negative impacts and negative outcomes can be quite tricky. And similarly with climate change, we've discussed that the impacts are usually indirect rather than direct. So rethinking the level of responsibility component of human rights due diligence could also be constructive. In terms of enhancing communication between affected right holders and investors, so we've tried, we try as much as we can to really get affected stakeholders and affected right holders to be in direct communication with investors and provide a voice from the ground, because more often than not, we see that corporates don't necessarily engage enough with affected right holders, and this is obviously something that then affects the quality of corporate human rights due diligence. So being able to create these channels of communication with between investors and affected right holders has been something that's allowed us to really raise awareness and get more investor action on these issues. I'll stop here. Sorry for the technical issues.
Thank you very much. That was really helpful and really helpful insight into towards, this complex relationship and the important role of investors. So our next two speakers are both from Nabylah LLP. Jason Reeves is an English solicitor and a licensed attorney in Texas and focuses on complex insurance disputes in England, the US, and other jurisdictions. Jason has worked for more than 50 years on issues related to climate change in the context of insurance, and currently acts in connection with the carbon majors litigation in the US. And Deepa Sutherland is an English solicitor with experience in international and domestic commercial litigation and mediation, and her practice at Nabylah has focused on liability defense and developing the firm's climate change practice. Jason and Deepa, thank you so much for being here today and for sharing your views. Thank you.
Excellent. Thank you, Lisa. You can hear me? Great. And the screen that you see, is it the full screen or is it the note screen? Okay, great. Thank you. Brilliant. Deepa, I think that I'm going to be driving and Deepa's going to be speaking to some of the slides, so just bear with us as we go through this. The first time that I found this photograph, I was pretty pleased. And everyone accused me of photoshopping it, but it's a legit photo from 1962. And it demonstrates some of the issues that we deal with in what we do as liability insurance lawyers. I'm going to hand over to Deepa, who's going to go through the opening couple of slides. Deeps.
Okay, first of all, thank you so much, Bickel, for inviting us to speak. This is something we're quite passionate about talking about, which will probably come across, and we're really grateful for the opportunity to share it with everyone today. We've heard a lot from the various panelists. We've touched on some ESG and some investor points. We're here to give what will hopefully be a different perspective, which is, where does the insurance industry fit in to the whole climate change discussion? Our agenda, thanks, Jason. We're going to be a very, very brief overview of where does insurance fit into this whole thing. To do that, we will look briefly at the role of insurance in the financial sector as a whole, the risk and exposure to the insurance industry from climate change, with particular focus on underwriting and claims. We'll also look at coverage concerns and strategic concerns insurers may have, and what all that means for insurers' reporting duties on climate change. It's not all doom and gloom. We'll also say how the insurance industry has a unique opportunity to actually shape this debate and argue why insurers should have a seat at the table. So first of all, where does insurance fit into the discussion? Climate change is a business issue. Climate change has an economic impact. Everyone knows this. To illustrate it, in 2018, the economic impact from natural disasters exceeded $160 billion. This included US hurricanes, Asian typhoons, California wildfires. In 2017, natural disasters cost the US economy almost $319 billion. Climate change causes loss. It puts businesses under the spotlight. It can result in regulatory actions, fines, lawsuits, reputational damage. And all these things fall on the business's insurers. And therefore, climate change is an insurance issue. Yet insurance is often omitted from climate change discussions. We hear a lot about the role of funds. We hear a lot about the role of investors. It's very rare we hear in a lot of detail where the insurance industry fits in. But since it's the insurance industry that picks up the bill for a lot of these losses, we would argue that insurance industry should be one of the main stakeholders in the climate change discussion?
I would echo Deepa's comments. Thank you for having us, and what a great panel to be part of. So this slide, why are we here? It's really not a metaphysical question. It really is meant to set out what we do, and we are coverage lawyers for insurers and reinsurers. We only work for insurers and reinsurers, so we're very niche in what we do. That might not be entirely clear, so we'll summarize what we do in 3 simple points. We determine whether or not a claim under a policy is covered. We then help determine how much should be paid by an insurer, and then we see if we can find a third party to hold responsible for that loss. And that is the only thing that we do in our career, in our day job. So we will fit climate change into those discussions. There's obviously a little subtlety that goes with those 3 points, but that will place you in where we're speaking. So fundamentally, liability insurers, our clients, have a duty to defend and indemnify policyholders against claims made by third parties. The easiest analogy here is most people will have car insurance, which will provide insurance in the event that they run a red light and cause an accident. Then you'll be protected by your insurance policy against claims that are brought by third parties. And the policyholders, in many cases, particularly the commercial ones that we work with, are being sued for causing climate change. They're being sued in a number of jurisdictions. There are a number of cases in Europe. The Total case was mentioned earlier. There's the RWE case, the Dutch case, which was successful, a number of other ones. We are increasingly focused on the number of cases in the United States, and we're actively involved in those. And what we do in connection with these particular lawsuits is we review the claim notifications. So after a policyholder is sued, they'll notify their liability insurer. And usually those liability insurers are insuring notifications from carbon majors. And then we provide our opinion on coverage and exposure to insurance and reinsurance companies. So our climate change litigation experience, we're instructed on a number of the active climate change lawsuits in the United States and in Europe at the moment. And so those are all open files. And I think from a litigation perspective, wearing a climate change hat, some of you will see some green shoots beginning to form with some of the lawsuits, which have been remanded back to state court in California and in Delaware. So there are some developments there that are going to overcome some of the previous bars. The role of the insurance in the financial sector, and Deepa's covered some of this already, but and it was really interesting to hear some of the other speakers about this. But fundamentally, insurers are investors. They make money 2 ways. They take premium and then they invest it. And so a number of times we find that investors have responsibilities, and even though insurers are large institutional investors, it's not clear oftentimes what their responsibilities are and exactly what they're investing in. I'm not sure that they're always included in the climate change discussion. And of course, insurers insure business and they help spread commercial risk and ease the wheels of the global economy by spreading risk and taking some of that risk on. Insurance is a core part of corporate risk management strategy. So, when a loss happens, somebody's going to walk down the hall to the risk manager who purchases the insurance. And the question will be, we're covered for this, right? And the answer from the risk manager is almost always, yes, we are. And of course, really, when it comes to spreading risk, investment, insuring businesses, it's all about providing financial stability. When we talk about risk and exposure, the insurance sector is uniquely exposed to climate change. It obviously has an investor risk. It also has shareholder obligations. And we know that some activist shareholders are beginning to hold insurers' feet to the fire in connection with how they're conducting business. And the side of the business that we're most concerned with as coverage lawyers is the underwriting side and the paying claims side. That's really how most people engage with an insurance company. They send a premium in and they submit their claims. And of course, insurers, because of that, are vulnerable to catastrophes caused by climate change, physical risks, liability, and we think that that climate change risk and exposure extends to virtually every business line, that no business line is excluded from the exposure to climate change. Trillions of dollars of damages and indemnity will be exchanged in connection with climate change. And I think that we're at the beginning of what will be 2 decades of long tail claims against policyholders. And then perhaps those claims will be presented to insurers and they'll be paid or not paid. And of course, there's always the increased vulnerability risks and the affordability issues and whether or not climate change is really something that can be insured, and maybe it's a sovereign risk rather than a truly an insurance risk. So a lot of you have certainly a lot more expertise with ESG than we do. And as we talk to insurance companies, which is who we deliver this session to mostly, you know, we often talk to the ESG teams, and this is going to sound bad. ESG, from where we see, is often a box ticking exercise. It seems to be a glossy brochure. It doesn't touch and concern the day-to-day business of investment, underwriting, and paying claims. And you know, a few of you have talked about mainstreaming. I'll steal that from you, Joseph. Mainstreaming ESG, and we completely agree. And this is what we tell insurers: it's only when the ESG is embedded in the core part of the insurance business when it's going to be effective. Otherwise, it is a fig leaf, and that's not going to be particularly useful. So, as I've already mentioned, with business lines, climate change impacts all business insurance lines. Last year, all of Australia was on fire. This year, California is on fire. You know, we can talk to you about all of those natural catastrophes. Virtually all of them we're very involved in. And of course, everyone has insurance. Every commercial entity has some sort of policy, and that's really the end that we are involved with insurance. I want to talk to you specifically about the liability exposures that we're concerned with. You know, when we talk about climate change liability insurance, we are mostly concerned with liability exposure rather than the modeling concerns and the what might happen and the theoretical things that are listed in the future. And we think that climate change risk is a new and emerging exposure to insurers, and certainly that is how our clients are beginning to see it. It is not a theoretical risk. It is not a future risk. It is happening now. Policyholders are being sued now, and claim notifications are being presented under policies now. So there are key coverage issues that come up in connection with all of these issues, and we have some very boring legal techie stuff on that stuff, which we'd be happy to talk to any of you about, probably not today though. And we also think that insurers can take some proactive steps to manage their exposure and you know, to engage properly with their duties in connection with climate change. And part of that is about underlining or aligning the corporate and underwriting strategy and the claims strategy that people might have. Really, you know, we are litigation lawyers fundamentally, and the first wave of climate change litigation in the United States really all is sourced from the Clean Air Act in 1970. 2007 to 2010 is really the first wave of climate change litigation. Comer, Murphy, and Kivalina is often cited, and these claims were dismissed at an early stage for lack of standing, remoteness of damage, and essentially the science wasn't up to proving that the carbon majors had caused some of this damage that was being alleged in Comer, Murphy, and Kivalina. The AES Corporation and Steadfast is the only case that exists right now on a liability insurer's duty to indemnify a policyholder who has been sued for causing climate change. And it's pretty interesting, but it's not a widely held precedent from Virginia. So We also have the second wave of US climate change litigation. This is actually what's keeping us busy in our day jobs right now. In 2018, there were 13 nuisance lawsuits. We're involved in all of these. And of course, in addition to the nuisance lawsuits, we have some financial and securities lawsuits that have been brought by states in the United States. And we can talk a little bit about those. But these are files that have largely been allowed to, some of them have been dismissed, but they're increasingly being allowed to proceed. And so it's the second wave of US climate change litigation, which we think is going to impact change in the insurance industry and the exposure to the insurance industry. So who are we talking about when we talk about the policyholders? Really, the lowest and easiest hanging fruit are the carbon majors. And this is a list of the biggest carbon majors. You can look at this as, you know, the carbon accounting table list of polluters from 1750 to 2010, or you can look at it as a list of blue chip premium policyholders who pay millions and millions of dollars every year in premium for their liability coverage. And behind every one of these policyholders is an insurance tower, usually for billions of dollars, comprised of most well-known insurers and household names in the world. And no one insures a single risk. Everyone takes a piece at different layers. And this is kind of what that looks like. So when we started working on climate change, it was very clear to us that we know, and the insurance industry knows, a number of these lessons. We've already learned them. Insurers have paid for us to learn them, but many of those lessons have been forgotten. Climate change exposure is really like any other long tail pollution or environmental claim. It is going to be litigated a lot like tobacco because of the knowing conduct of many of the carbon majors. It's also going to look like asbestos and about MTBE when it concerns the actual reinsurance coverage in place. So, you know, so far we've had a lot of difficulty. The people who are being sued, there's been difficulty in actually being successful in suing the policyholders. A lot of those claims have been dismissed at an early stage. And there's some fundamental questions about causation and whether or not you can hold these emitters responsible for historic long tail pollution. And, you know, there's some interesting arguments out there, and certainly the science is developing in connection with this. And, you know, I like to remind people when I speak, particularly to insurers, it took about 50 years of tobacco litigation beginning in the late 1950s until the first meaningful judgment in February 2000 before a tobacco company was held liable in connection with causing cancer and its knowing deception on the public. And so we had the first wave of climate change litigation, which began around 2007 in the United States. And my question to you is, do we really have another 50 years before jurisprudence catches up and changes the way that these issues are seen in the environmental context? I suggest it's not. Deepa?
So what would insurers reporting on climate change look like? In the broadest terms, insurers, reinsurers are companies like any other corporate, and they're subject to their own reporting requirements. However, something peculiar to insurance companies, when they're reporting in terms of their own investments, they are, after all, major institutional investors. They can open themselves up to criticism for investing in the very things that cause them losses. And this is the disconnect between their investment side and their underwriting and claims side, which should also be subject to reporting. But that's always not fully addressed by the ESG, the underwriting claims side. But that's where they pay out the money. And as Jason said, when we talk about something like climate change, we're talking about billions, trillions of dollars changing hands. And so it's that underwriting and claim side that's absolutely fundamental. In terms of shaping behavior, it's also important to remember that it's the underwriting and claims side whereby insurers are picking up the bill for corporates' liability. So a corporate might be held to account for climate change, but it's the insurance industry that's actually cushioning the impact of any sanctions that the company itself receives. Again, it begs the question, we can have principles, but how are they actually enforced in practice? And it's arguable that the insurance industry has a role to play in that. And for these reasons, we would argue that insurers are actually more exposed than other businesses to the risks of climate change. However, as I did say, it's not all doom and gloom, because this also presents an opportunity. Insurers, being in their position, could affect change. They could shape behaviour through their own investment policies, through their underwriting policies, through bringing about new and creative insurance products to specifically deal with the specific effects of climate change.
So we get asked this question a lot when we present to insurers. Well, we don't want to be the first insurer who changes our mind about how we approach climate change liability and our liability policies that we issue. And they raise a couple of points. You know, some of it is straight commercial, but there's a fundamental legal question as to whether or not, by changing their policy now, does that affirm the coverage that perhaps previously existed? For a number of techie legal reasons, we think the answer to that is no, under English law and in most US states and in most other common law countries. So we're not particularly concerned about that. We are aware that it can be difficult to go first. And of course, one of the problems that you know, insurers fear really goes to the due diligence aspect of, you know, if we set a benchmark, can we be held accountable to it? And there's a little concern about public statements in that connection. And I'm not talking about the ESG statements. I'm talking really about what happens when the rubber hits the road for an insurance company in its core business. And I see a lot of insurers saying, well, we're not going to insure coal anymore. We're not going to insure the carbon majors anymore. And that's absolutely fine. And I understand why you would want to put that in your ESG publication. However, we know that all of those industries continue to exist because they're still part of the modern world, and they're almost all reinsured. So you might not insure them, but you do reinsure them. And I think the way the insurance industry changes and impacts climate change is when the 6 or 7 top reinsurers in the world, we can name them, their household names, when they change their inwards treaty obligations with the insurers who buy reinsurance from them, then I think we'll see significant changes in the insurance and reinsurance industry. So last couple of points, really climate change exposure, it does fall back onto the insurance industry. Insurance is uniquely exposed to climate change, and exposure to business, exposure to companies means exposure to insurance, not only on the investment side, but really on the underwriting and claims side, which is often what we see. And we think because of that, insurance should be at the core of climate change discussions. And if it's not, then there's really a big seat missing from that table. Great.
Thank you so much, Jason and Deepa, for that really interesting presentation of the insights, unique insights from the insurance perspective, which are also lessons that are really very important for us to keep in mind in the wider conversation as well. I just wanted to apologize. I know we're running over time, and I wanted to reassure everyone, all registered participants will be receiving a recording in due course of the entire session. So if you, I really apologize, but if you have to go, hopefully you will be able to still see our last excellent speaker as well. Katie Xiaohui is Director of the Global Business Initiative on Human Rights. She leads GBI's external engagement with business practitioners and other stakeholders around the world, and oversees the growth of GBI's unique by business for business resource, the GBI Business Practice Portal. Thank you so much for joining us, Katie, and I'll hand over the floor to you now.
Thank you very much, Lisa. It's wonderful to be able to join this discussion today, and I'll try and be as concise as possible so that everyone who needs to be elsewhere can get there. But I think this is a really important and timely discussion. You know, we're seeing increasingly mainstream acceptance that there's some urgency, real urgency around addressing the climate crisis. We're seeing more and more businesses pivoting their operations, their activities, their forward-looking strategies, and making bolder commitments around climate. We're also starting to see more convergence from government at the policy and strategy level, between climate change, concerns about human rights, concerns about governance, and all of this in the context of a potentially, hopefully one day, post-COVID world. And so I think there's a real need to start connecting up the dots here and figuring out how the due diligence that businesses are doing already on human rights joins up with their responses to climate change. I'm going to focus my remarks very squarely on this link between human rights due diligence and business responses to the climate crisis. I know when we talk about human rights due diligence for climate change, it means different things to different people. To some people, it's thinking about climate change due diligence, thinking about the end impacts on people. To some, it's about other things. I want to kind of really take a broad view of all of the different responses, transitions, changes that companies are going to have to make, both to reduce their emissions, but also to adapt to a warmer world and build resilience in their business. So getting to that kind of just transitions concept that Nabylah discussed. And my aim over the next few minutes is to leave you with some thoughts on three things. So firstly, just a sense of kind of the breadth of climate change related decision making and action businesses are taking that can impact on human rights and impact on people. Secondly, some practical approaches that companies can take to start to expand the coverage of the human rights due diligence to also encompass the work that they're doing on climate, and some common challenges that we're hearing from the companies that are starting to think about that. And then finally, three very brief ideas about what could be useful from different stakeholders to advance work in this area further, ideally quite quickly, given the urgency of the situation. And I'll be coming at this very much from a practical perspective. I work very closely with business practitioners and other stakeholders in this space. I'm not a researcher. It's been many years since I was a practicing lawyer, so I'll try and keep everything as practical and concise as possible. Starting with this connection between human rights due diligence and climate change, my kind of front of mind observation is that this connection isn't intuitive to many people. Through the conversations that we have within the Global Business Initiative on human rights, with our member companies, with other businesses we engage with through regional workshops, other stakeholder discussions we have, this topic is increasingly coming up, but we're often hearing a couple of misconceptions. First is that the work that companies are doing on climate change is part of their overall sustainability work. It's directed at improving the company's sustainability, therefore it's not high risk from a human rights perspective. So the human rights team don't need to worry about that as much as they do, say, modern slavery or other issues that are front of mind. The second misconception that we hear is that this is primarily an issue that extractors companies need to worry about, and that there are a number of industries for which this is not a big priority. I want to very quickly debunk both of those myths. Firstly, this idea that because climate change is being led by people within the sustainability team, that it doesn't come with human rights risks. There's a reality that folk that are working on reducing the company's emissions are focused on environmental impacts. They know an awful lot about that. They're very focused on improving that situation. They don't always have impacts on people front of mind. They assume the human rights team are dealing with that and will let them know what needs to be done. So there can often be a disconnect. I think Colleen referred to this as well, between those two teams. But also because the responses that companies are taking to climate change aren't just being led by the climate team. A lot of it's around business decision making, what markets to get into, what markets to get out of, how to think about where the business is positioned and the geographic risks that are being faced, that are not always being thought of as kind of climate change work. And so again, that's not necessarily something the sustainability team will be thinking about. I guess a couple of other examples of that would be, say, automotives that are pivoting towards battery operated vehicles. That's a great outcome from the environment if we can reduce dependence on fossil fuels, but that gets them into value chains around lithium and cobalt that are hugely risky from a human rights perspective, around artisanal mining and conflict minerals and that entire world. Similarly, the shift towards reusable packaging, great from the from an environmental perspective, but can get into human rights issues around forestry use, land use, impacts on local communities and livelihoods, etc. So these are challenges that are really very widespread and that are relevant to pretty much all companies. Yes, extractives are very much to excuse the pun, the coalface of the issue in terms of really having to reinvent and pivot their entire business model. But all companies are going through an adaptation process, and they need to be alert to the human rights risks that all of those various decisions, big and small, it can have on people. So in terms of what that then means in terms of the human rights due diligence that they should be doing, I think it's fair to say that companies are in very different places on this issue. For many, it's very new, and generally I'd say practice is pretty nascent. In theory, though, it's just bog standard human rights due diligence. The expectations of the UNGPs here aren't different because the risks are associated with climate-related decision-making. It's human rights due diligence, and that's supposed to apply to all of a company's operations, activities, business relationships, and climate-related decision-making is just part of that. So the steps that Joseph took us through earlier in this session around ensuring that you've got processes in place to assess risks, to prevent, mitigate, remedy them when things go wrong, that all should be happening around climate. The reality, however, is that there are still gaps in company practice. Part of that, I think, is because, as I mentioned, the connection between the work and the decisions companies are making on climate isn't always joined up to thinking around human rights. Part of it's just part of the reality that the ask the UNGPs make of companies isn't something that can be implemented overnight. And many companies are still at an early phase of rolling this out, of building comfort, talking about human rights with their colleagues, building that practical internal know-how, and they just haven't gotten to this yet. Sorry, I just lost my train of thought. So there's a real need to start to kind of advance practice in this area. In the conversations we do have, there are three things that are coming up a lot. Firstly is this challenge of building a shared vision and a shared language between the human rights team and the climate team. As one practitioner put it to me recently, we speak people, we speak in qualitative terms, they speak maths and science. And there's a process to go through to find that kind of way to connect the dots and build a joint understanding around what can we do to reduce the company's environmental footprint in a way that respects and doesn't create additional risks to people. That's not that different from the work that companies have to do to build that connection with their colleagues in legal, with their colleagues in procurement. It's just a relationship that needs some time and needs some thought and some effort behind it. Secondly, getting human rights due diligence integrated into early decision-making. I think I mentioned earlier that part of this is about decisions that companies are making to exit problematic markets or get into new markets. And we've seen, already from conversations in the space in recent years about integrating human rights due diligence into M&A decision-making, that can be really tough. Partly because these decisions are made at very senior levels, but they're also often made on a very tight time frame with a huge amount of commercial sensitivity and a very small number of people involved. And it can be very difficult to ensure that one of those people is a human rights expert. Ideally, that is the position that companies will get to, where you actually have a human rights expert in on these decisions, these big strategic decisions that companies are making. In the meantime, it's really important to prioritise building the human rights know-how of those who are at the table so that they can at the very least spot the issues, understand why it's important that they're addressed early, and then engage with the company's human rights expertise when things comes up, human rights expert when things come up. Then finally, crisis management, a very pertinent topic to raise right now, but it seems almost inevitable that companies will increasingly be navigating climate-related crises. And it's becoming ever more important that human rights expertise is integrated into their approach to crisis management. Again, this should be nothing new, but we know that many companies are not there yet, although hopefully COVID has provided some opportunities to start to strengthen this. Again, it can be difficult to make the case for this, and in a crisis things move quickly, but actually ensuring that there is that expertise in the crisis management team, or at least that ability to spot the issues and engage the human rights expert early when things come up, is going to be pretty critical. So finally, how do we push this forwards? As with all complex problems, we need to find coordinated ways to address these challenges from a number of angles. And there are three things that are front of mind for me right now. One is improving coordination and convergence at a number of different levels. So for example, at the level of government policy, we're seeing efforts to strengthen and introduce mandatory human rights due diligence requirements. Those are then being joined up with environmental due diligence requirements. There are increasing commitments around climate under the Paris Agreement, a whole world of stuff happening around COVID recovery. This needs to join up, and we need to get everyone pulling in the one direction, but ensure there's some coherence as well, so that the work that's being done to address these different things isn't working at odds with other efforts. We also obviously need to get some more coordination and coherence within business and within financial institutions to ensure that the right teams are talking to each other. I think on many fronts that is well progressed, but we see some gaps between climate and human rights. And then finally, in the broader business and human rights space, in advocacy and research and collaboration, I think there's a real need to build bridges between the world of business and human rights and the world of climate change, and start enabling more joined up discussions, more coordination. Because I feel like a lot of the thinking is not that far apart, but because we don't talk to each other, we're missing opportunities to really align, but also to streamline some of the work and the effort. Second bucket of things would be, and it's a very fast one, improving access to practical examples of action that's being taken. Certainly from our conversations with business, but I think also with others as well, it's not always easy to get a tangible idea of what does it look like to do human rights due diligence for climate-related decision-making. And the more examples of practice we can get out there, the more ideas and inspiration we can get out on the table, the faster practice will start to move. And then finally, and less tangibly, I think we need to get more comfortable with complexity and with not knowing. Climate change and business and human rights are both very, very complex, global, wicked problems. As I think we've all been discussing over the past hour and a half, it's very important that we start to bring these worlds together, and that we find ways to develop new thinking, new ways of living, new ways of working. But it's hard. They're both areas that are characterized by huge complexity. There's an enormous amount we don't know. There's an enormous amount we need to learn. How does an intervention over here impact this thing over there? How does that change when you also have an intervention over here? At some level, I sympathize with the instinct to try and simplify and to make things practical. That is important. We need to not overwhelm people and find ways to make that, taking that first step, a bit easier. But alongside that, I would really urge all of us to embrace the need to learn together about how to shift these big systems. For those of you who are at the Next Generation Trade event about a year ago now, Kumi Naidoo, the Secretary General from Amnesty International, said something about creative maladjustment. This idea that we're all part of these systems that aren't working, and we need to get unused to them in order to be able to see them more clearly and invent something new. I see a real need to lean into this uncomfortable space and be able to question that status quo and build a new vision. And so I'd also urge us to resist this inclination to simplify things. These are not complex problems, and we need to work hard and work together to overcome them. Thanks, Lisa. I might leave it there.
Thank you so much, Katie, for such a clear and insightful wrap-up, not just of this final episode, but actually of the entire webinar series. We've really seen that there is a need for further conversations, further thought, further research, for the practical examples. And that's also obviously what we then hope to do at Pickle going forward. So thank you so much for all our speakers who joined us today, and also the participants, and apologies again for the overrun. And we will be in touch hopefully shortly with the relevant links that we promised. Thank you again, and I hope that we will be in touch soon.